A plaintiff's assumption of risk can be a defense to a negligence claim. So what must a defendant show to establish this defense? The South Dakota Supreme Court addressed this question in Ray v. Downs. Harold Downs owned a farm. Experienced farm worker Donald Ray worked on the farm. At harvest time, Downs hired a company to harvest the farm's soybeans. Although it wasn't one of Ray's farm duties, Ray offered to help harvest driver Phillip Waldner unload a trailer of harvested soybeans. Ray and Waldner agreed that Waldner would move the truck while Ray positioned the auger. Ray would use hand and voice signals to let Waldner know when the auger was in position and that Waldner should stop. Ray stepped near the truck to position the auger. Waldner then drove the truck forward as Ray swung the auger underneath it. But Waldner didn't hear or see Ray's voice and hand signals and drove too far, running over Ray's leg and hip, pinning him to the ground. Downs heard Ray scream and ran over, stopping Waldner and getting him to drive off Ray. Ray and his wife sued Downs, Waldner, and the harvest company, alleging that their negligence had caused Ray's injuries. At Ray's deposition, Ray admitted that he knew it was risky to stand near the tires, but Ray claimed that he believed he was safe because Waldner would stop when Ray signaled. The trial court found that the undisputed evidence showed Ray had assumed the risk of being injured and granted summary judgment, dismissing the case. The Rays appealed to the South Dakota Supreme Court, contesting the dismissal of the claims against only Waldner and the harvest company.